The order appointing a guardian of a legally incapacitated individual. In this particular case, we're only referring to adults. Hi, I'm Darren Findling of the Probate Pro, and we're going to cover this particular scale form PC 632, scale for State Court Administrative Office, PC for Probate Court. This particular form we'd be happy to provide you free of charge. If you have questions about filling it out, give us a ring. We're happy to explain it to you. Now, with all of these scale forms, these pre-printed forms, they are created by various statutes and court rules. And as you can see from the floating yellow arrow, MCL 700.5312, MCL 700.5313, and the court rule MCR 5.403 give rise to this particular order for the appointment of a temporary guardian when a full guardian has not been appointed. So let's work our way through the form to understand how it is utilized, how it is filled out. I will also mention that with all of these forms, with all probate-related issues and guardianship-related issues, we strongly urge you to work with a skilled, competent probate lawyer to understand the statutes, court rules, the language that's used, the process. It's not easy. It's confusing. It's not intuitive to just navigate through this process. Also, this form is used as following already the court hearing. So you've got a petition that would be filed requesting the appointment of a guardian. That matter would have been served with the petition and notice of hearing upon all the interested parties. There would have been a hearing on the petition for appointment of guardian, and then an order would follow for entry. So the court speaks through its orders. The petition is the document where you're making the request of the court for the relief for what you're asking of the court to do. So again, this order is used at the tail end of that petition order process to appoint a temporary guardian of an individual for an adult only. This would not be used for a minor. In the top left corner is the county, top right corner is the case number. In the matter of, quite simply, the name of the individual upon which this guardianship is involved, the date of the hearing, the judge, and if there's a P number, if you could identify the P number of the judge, that's the professional number that's utilized to identify any active attorneys in the state of Michigan. The next section reflects the findings of the court. So the court would make findings relative to the petition. Let's work our way through it. First, with all petitions, notice has to be given. Notice is required to the interested parties as defined under statute and court rule. Notice would have had to have occurred to the alleged incapacitated individual. So in a guardianship context with a full guardian, there is a lot more due process that's afforded because all the interested parties are provided notice. There is a hearing. With a temporary guardian, it's done in an emergency, often in expedited fashion. So in this particular case, notice must be given to the alleged incapacitated individual. And there are particular rules about what that notice looks like. Their notice that's provided to them, as well as what information is conveyed to them about the petition by either the petitioner or the guardian ad litem, letting them know that there is a temporary guardian request being made that will affect their rights, their individual rights, and if that guardian gets appointed in that temporary capacity, there's a suspension of many of their rights and their autonomy to make decisions on their own behalf. So it's really critical that that notice provision is appropriately afforded to the person that is alleged to be an incapacitated individual. Now, temporary guardianship is just not randomly given out. It's not given out in most guardianship contexts. It's utilized in very narrow contexts in which there is some decision that needs to be made on behalf of the alleged incapacitated individual that is really imminent, life-threatening. Decisions have to be made immediately. And the reason for this is that rather than the typical time frame upon which the individual is afforded due process, this is being done in a very hurried, rushed manner that no longer gives the typical time frame for objections and time between the petition and the order. This is done quite quickly, in which there is a decision that needs to be made that is typically life or death without that temporary person in place. So let's work our way through the form, continued our way through it. Section 3 provides that this would be a denial by the court if the individual is not in need of a guardian. Section 4 provides the individual does not have a guardian, but an emergency exists. So there's some imminent circumstances that are affecting that individual. Maybe there's a health crisis that's going on, an accident that has occurred, and no other person appears to have the authority to act in the circumstances. So what does that mean? That there is no power of attorney that's in place that already granted the authority to a third party to make decisions. Now, a showing has been made that the individual is incapacitated. So this would be a finding by the court that the person is incapacitated. So there has to be evidence to that effect. Section 5 provides that the appointed guardian is not effectively performing his or her duties. So there's already a guardian in place, but that person has failed to perform their duties, and the welfare of the incapacitated individual requires immediate attention. So that circumstance for Section 5 would be that there's already a guardianship in place. The guardian has already been appointed, but that person is not performing their role in such a manner such that it puts that individual at risk. There is an emergency, and the welfare of the incapacitated individual requires immediate attention. The court is essentially suspending the power of the existing guardian, appointing a temporary guardian to make decisions during that time frame. 6, there's no qualified suitable individual to act as the temporary guardian, and the appointment of a nonprofit corporation will be appointed as temporary guardian, which is in the best interest. So before the court can appoint an agency or a nonprofit corporation to serve as the temporary guardian, the court has to make findings that there are no other suitable individuals to serve. So no other family members have come forward. There's no other suitable people within the sphere of that person who is under protection, and the court is going to appoint an agency, an entity, to serve as the temporary guardian during that time. And there's a requirement for a personal bond to be filed. That's one of the requirements under the statute. So if you notice under those findings, 3 through 6, there's also a 7, which is the other, which the court can make other findings. And it's not just limited to the space there. There could be other findings that the court may make. But these are not, they're checkboxes here, which means the court can make some of the findings and not others. As you move further down the document, this is the order of the court. So after the findings of the court is now going to enter an order. Section 8 provides that the petition for temporary guardianship is granted, denied on the merits, or dismissed and withdrawn, meaning it's withdrawn by the petitioner or dismissed for some reason. Maybe the person has passed away between the petition and the entry of the order. This happens, sadly, quite often. Section 9 is a space for the person that is being appointed, as well as their address. It indicates that they're appointed temporary guardian, and they shall qualify by filing an acceptance of appointment. That's another scale form of which I've done videos explaining how to complete that form. It says, I accept the role of temporary guardian. Now there's a section 9A, and we'll see on the back side of the document a section 9B. Let's work our way through some of the items here. The temporary guardian shall have all the powers. The first one is all powers and responsibilities granted and imposed by law. So this is like a full range of authority on behalf of the guardian. And there can be some exceptions that would be identified here. And then on the letter of guardianship, those exceptions, limitations would be reflected. Or the other way the court can do this is simply give specific powers. So for example, the power may be to intubate. The power may be to do a transfer or a discharge of some sort, or to move from one hospital to another. Again, I'm just giving some examples here of how this form may get filled out. The next box, it says, in addition, the temporary guardian has the authority to execute a written consent for formal voluntary mental health treatment. So again, if there's mental health related issues, this can also be utilized, but it also provides an objection opportunity by the person. So the alleged incapacitated individual can object to the voluntary mental health treatment, and then there's a process that follows related to the objection by the individual under Michigan's mental health code. Again, there may be a bond, which is a guarantee of performance that is required by the court. So if that bond is checked, again, I've explained how bonds work in other videos. It can be a little confusing. And again, with all of these proceedings, we urge you to work with a skilled, competent probate lawyer to guide you through this stuff. The back side of the form, section 10 says the temporary guardian is not permitted to act until the letters of guardianship are issued. Here's why this provision exists. The order itself that appoints the guardian may have requirements, conditions precedent before the powers of that temporary guardian can act. For example, if a bond is required, or the acceptance of appointment is required to indicate that they're qualified to serve, or as a condition, for example, with the bond as a condition precedent before they can serve, the order itself does not indicate that the bond has already been approved and filed. So the acceptance of appointment and bond with the order would then allow for those letters of guardianship to be issued. And the letters of guardianship are the evidence of the appointment of the guardian and provides the authority for that guardian to act, as well as within that guardianship any limitations of power. So that's why section 10 provides that they can't act until the letters of guardianship have been issued. And then there's a termination for 11. Quite often there's a termination because then there's going to be a full hearing on the full appointment of a guardian, or maybe a review of the temporary nature of the guardianship to ensure that the circumstances haven't changed. Because often in a temporary guardianship situation, things are dynamic. People's health are changing and decisions are being made quite quickly. So the court wants to keep apprised of what's going on to understand what needs to occur. And often there's a termination date on there so that there may be a renewed hearing date, maybe a status update or renewed proceedings on the guardianship. Section 12 provides for further orders of the court, and often the court will not just limit itself to that little space, but provide additional order depending on the circumstances of the individual. A spot for the judge to sign and date, as well as the attorney if there's an attorney involved in the matter. Again, this order for temporary guardianship, not an easy thing to navigate through. We urge you to be working with a skilled, competent probate lawyer. At the Probate Pro, we are passionate about everything probate. If you have questions about this order or any probate or trust, guardianship, conservatorship related issue, visit us at theprobatepro.com or call us at 1-833-PROBATE.